comes up, and I understand things were cut up, but is it fair to the defense then suddenly to bring this in at the last minute?
Your Honor, it was information that there's no other way that we could have gotten it. And there's the idea that you always seasonally supplement, and that's exactly what we did in this case. This litigation is especially truncated, and it has to be that way, and we understand that. But data that there's no way for us to have had at that deadline that the court set. That's why the court has discretion in these situations to say that since there's no possible way that we could have had this information by November the 25th, there's no way that we could have produced this specific information. We did tell them that Jesse Kamsel was going to be a witness in this case, and indeed, he did give deposition testimony in this case. He gave deposition testimony in this case on other data information that came out within, I think, at roughly the same exact time as this information was produced to us by the Department of Motor Vehicles.
What about the requirements of NRS 293.415? Basically, this matter be heard upon deposition and argument. They have no ability, basically, to cross-examine him on this new additional material. No ability at all to question his methods or methodology in respect to that new material. Is that fair?
Your Honor, I understand the court's position on that, and I would say that the better remedy that would meet the interest of justice on this is to allow them to do just that after argument, to allow them. We can do that tomorrow. We can do that, this evening, and then we can submit the deposition supplementally to the court for its decision. That would be something that could meet the interest of justice to still allow them to cross-examine Mr. Kamsel on these issues without denying us any reasonable means of bringing this to the court's attention, since there's no other way that we could have gotten this and to submitted it to them any earlier. We literally submitted this at the earliest moment we could have in order of getting the data, comparing the data, producing a very short report explaining how the data was compared, and then providing it to the defendants. They should have the ability. But they certainly have the resources available in a document subpoena situation to use their own experts, their own resources to compare this data and say if they think that we got anything wrong, that it's fewer than 4,000 non-citizens who voted in this case. They haven't done that yet. They've had, at this point, a similar amount of time that we've had to do this, and they haven't done that. But if they want the opportunity to depose Mr. Kamsel on that, we'll make him available for a deposition, a very short deposition after this. We can submit it to the court supplemental without further argument.
Mr. Hamilton, any final comment on this issue?
Your Honor, took the words out of my mouth. The statute anticipates evidence to be presented by deposition and the argument of counsel. That hasn't happened here. This contest was filed on November 17th. That's quite a while ago. And counsel had plenty of time to secure whatever data he needed and to produce this declaration or expert testimony. Your Honor gave clear deadlines. If there was some issue, then counsel certainly could have filed an emergency motion for the court for leave, or even approached us for how to deal with that. He did neither. The court has indulged counsel at every turn by providing ample opportunity for discovery, but this is both inconsistent with the statute and fundamentally unfair to the court and to the defendant. So we would ask that this.
Thank you. Certainly the order of the court, go ahead and strike the supplemental declaration of Jesse Kamsel. I believe for the reasons I clearly indicated, stated one that had a disclosure deadline of November 25th, 2020, which I might add, none of the other experts by the claimants were even disclosed on that date. They were all disclosed later in respect to that. I don't know about disclosure, but the reports were not done until like November 30th, I believe, in respect to that. But I don't allow all that. I'm not striking anything other than this current declaration for two reasons primarily. One, its way. Two, primarily under NRS 293.415, it's clear to this court that I am basically limited depositions and argument in respect to making a determination in this case in regards to that. And the reason for that, clearly in the court's mind, is an ability to cross-examine and verify the information and make sure that basically is fair to both sides. So, with that in mind, I want to move forward in respect to that. It's my intent to give each side approximately an hour. We may take a break somewhere along the way in respect to this matter. In regards to that, you can reserve part of your time for rebuttal. Each side, you have an hour. So if you want to go 30 minutes and reserve your time, that's fine with the court. However you want to do it in respect to that is fine. I do have one other question that the court thinks is important to start with, and that is, what is the evidentiary standard that applies in respect to this particular matter? I think it's important that we go through the evidence and look at the evidence, that we understand what the standard is that we're going to apply. Is it a clear and convincing standard, or is it a reasonable doubt standard? So given that, Mr. Pinal, if you want to comment on that. Again, just short, I've read all the briefs, and that's short. I'm not making a decision which way. I just kind of want to give a flavor for everybody and what the course we're going to look at.
And I understand that that would be an important point for the court to consider, is because the statute itself is silent on the standard of proof that would be required in a case like this. The defendants have cited law in other jurisdictions, but of course, since this is a creature of statute in Nevada, it would be more appropriate to look at how Nevada handles situations like this. The default is always in a civil case, preponderance of the evidence. That is the default burden in a civil case, and this is a civil case. It's an unusual case, and it's understandable why there wouldn't be a lot of case law defining some of this. But short of any intent of the legislature, and we're aware of no other intention of the legislature to increase the burden of proof to a clear and convincing standard, as the defendants urge the court to do, the right thing to do is go back to the civil standard that we are very familiar with, which is preponderance of the evidence. From a policy perspective, that's the right answer too. We are trying, as the court said when the court took the bench, to determine whether every vote was properly counted, every legal vote was counted in an election like this. There is no reason to give more deference to one side or the other in that determination. The proper thing to do is to weigh the evidence to see whether or not the decision to certify the electors for Vice President Biden was appropriate. And so consequently, since there's no reason to favor the defendants more or the contestants more, the preponderance of evidence standard is the appropriate use here.
What about NRS 293.410, which talks about reasonable doubt? It uses kind of a reasonable doubt throughout that. It talks about reasonable doubt. Is that similar to preponderance of evidence, or is that a little higher standard?
And that's an interesting use of reasonable doubt in that statute, because it's not the reasonable doubt, very clearly, that we would be used to in a criminal case. It could be read to say that it could be read to offer a standard much more favorable to the contestants, quite honestly, of saying that if there's a reasonable doubt in the outcome, that the contest should be granted. It's difficult to see exactly how that would work in the civil setting, Your Honor. And that's why I think it's more appropriate for me, and quite honestly, hopefully it gives me a little bit more credibility to you to say I don't have to just throw up as somebody sitting on this side of the courtroom who has a burden, some burden, that I just have to have almost like a probable cause type standard. I think it does have to be more than that. It has to be that we do have a burden to meet here, a burden that we will meet, that we're very confident we will meet. I think the way a reasonable reading of the reasonable doubt language in 210 means that it's similar to the preponderance of the evidence standard that otherwise the court would use in this setting.
Mr. Hamilton?
Well, Your Honor, I agree with counsel to the extent that the Nevada Supreme Court has not yet defined clearly the burden of proof required in an election contest. But an election contest, by its nature, is asking a court to do an extraordinary thing, which is overturn the results of a certified election. And so for that reason, courts around the country typically embrace a clear and convincing evidence standard. California, Illinois, Kentucky, Maryland, Montana, Ohio, Oregon, a variety of states. We've cited them all in the brief. So it has, obviously, if the statute set a standard, that would be the standard that would apply, or if the Nevada court had spoken, that would be obviously controlling. Here we don't have that, so we have to look at, I submit that two things guide the standard. First would be how are election contests treated elsewhere on similar statutory schemes, and that is they use a higher, clear and convincing evidence standard. Second would be more of a functional approach. The cause of action sounds, at least in part, in fraud. And fraud under Nevada and the law of virtually every state requires a higher evidentiary standard. So for both reasons, I think that the clear and convincing evidence standard is the one that should be applied by the court here. Ultimately, and I know you don't want me to argue the rest of the merits of the case, ultimately I'm not sure that it's positive here because I think the claim fails under even a more relaxed preponderance of the evidence or reasonable doubt standard, Your Honor.
Well, I would reserve going on that issue because I think it's kind of a difficult issue in regards to this, and it may or may not make much difference when we get down the road. The other question I have is there was a certification of the election results by the Nevada Supreme Court. Does that have any impact on this hearing? And again, if you look at the statute and the timetables that things have to be done under Nevada law, and you do have time periods in which to file a contest and it was filed properly within the time period. So I'm not sure it technically has any impact. So just a final comment.
Your Honor, I think that's a very good question, something that we looked at.
I always like to hear that. I asked a very good question.
It's a good question from the very nature of the fact that came from the bench, I know. Your Honor, the contest statute is I think, quite clear about the timing and the fact that the ministerial action of certification by the Secretary of State and then the governor does not take away the court's ability to enter an order on a contest. Of course, just by the timing that the General Assembly has laid out on that, I think is very clear. And up until, matter of fact, the law actually is that you can see from the legislative history on the contest statute that it is anticipated that the timing has to be so truncated because no one is able to take the oath of their position until the contest is decided. And so that is the important time frame to look at for the contest position, is to actually go down the legislative history. If we haven't cited that, we can get that and provide that to the court. That the important thing is whether they've taken their oaths to actually then begin their terms, and they can't take those oaths until the contest is actually decided. And so that would be separate and apart from the certification process by the Secretary of State. Otherwise, the timing laid out by the legislature just would be impossible for there being an election contest at all. It would render the entire statute a nullity.
Thank you. Mr. Hamilton?
Your Honor, I think Nevada law speaks to that in NRS 23417, sub 4, whenever an election is annulled or set aside by the court, and the court does not declare some candidate elected, the certificate of election or the commission, if any has been issued, is void and the office is vacant. So I think, without having spent a lot of time thinking about it, that the action by the Nevada Supreme Court does not prevent this matter from going forward to a judgment.
Thank you. I agree with both of your thinking in respect to this matter regarding to that. So at this time, basically, the court's prepared to go ahead. Now, if you want to start with the argument, again, we're kind of limiting everybody to time. You can reserve whatever time you want. The law clerk is keeping track. She's very open at this, so. And I want you to know that I've read all the briefs. Gone through the briefs, gone through that, and I've read as much of that as I possibly could from 5 o'clock until noon today in respect to that, and there's a significant amount of pages there, but I concentrated primarily on what both counsel know. I read primarily the depositions of the experts in regards to this particular matter. I spent a good deal of time going through that, and I felt that was probably one of the most important places to start, so with that way.
And, Your Honor, we understand that there's a substantial amount of submissions in this case, in a very truncated position to get it all forward for the court. I was reminded of the old adage that if I had more time, it would have been shorter. In this case, we think that almost everything that we have given to the court is something that is important for the resolution of this matter. It is all critical information that we've been able to gather in a month, and we appreciate the court's consideration of that and taking up all the time that the court has in looking at everything. We are actually also just put together something this morning that we thought might be helpful, and that is an additional exhibit index that gives the particular exhibit and which binder it's in for our binders. Can we hand that up to the court?
Yes, absolutely.
Okay.
I'd like to have that. Thank you very much.
Thank you. And we will make sure that we get one of those to opposing counsel promptly as well, if it hasn't already. Your Honor, I'm going to go for about 35 minutes right now, and then I'm going to withhold the rest of my time for rebuttal, if I can do math. Your Honor, this case